Welcome and thank you for joining us this morning for the QBCC's Important Changes for Adjudicators webinar. Before we commence, I would like to acknowledge the traditional custodians of the land at each of the locations that we are at and pay our sincerest respects to elders past, present and emerging. My name is Regan Greer. I'll be your webinar MC this morning. We anticipate that this presentation will run for about an hour. I'd like to quickly explain how the webinar will run. Our presenters this morning are Sheridan Farthing, the Adjudication Registrar, and Megan Johns, QBCC's Director of the BIFOLA Project. Now, there's a large number of you logged in to hear about these newer enhanced laws, which commenced on the 1st of October. That means you might have lots of questions. So if you do, you won't be able to ask it out loud. However, what you can do is you can type that question into the on the right-hand side of the screen, there's a task panel, and in there, there's a questions field. You can ask those questions at any time during the presentation. And just to keep the flow of the presentation going, we're not going to immediately stop and answer that question. What we're going to do is we're going to continue on to the end, and then we're going to read out as many of your questions as possible and provide answers. What we will do after this webinar is we're going to collate all of your questions and get them answered in writing for you, and we'll email them out to you in a complete pack. And that pack's going to contain a copy of today's PowerPoint slides, the updated Adjudicator workbook, and also a link to a recording of this webinar session so you can go back and watch it at a later date. Now, you can also claim a CPD point for your attendance today. You can record this webinar as a CPD activity through the online My CPD portal. For more information, please review the guide, which will be included in that pack that we're going to email out. At the conclusion of today's webinar, a survey will pop up. We'd really appreciate your feedback on the presentation and your webinar experience today, because what you tell us will help shape how we deliver information and education to you in future. Now, this morning, we're going to take you through some of the updated building and construction laws impacting the adjudication process in Queensland. So on the agenda, we're going to look at what BIFOLA means, as well as a background to it and overview of some of the reforms that have come in under the BIFOLA. And we can take a deeper look at the BIFOLA reforms and what you as adjudicators need to know about them and how to comply. Specifically, we're going to look at a range of security of payment changes affecting the payment claim and adjudication processes, as well as the responsibilities of adjudicators. There are also new enforcement options available to claimants seeking payment of adjudicated amounts. I'll now hand over to Sheridan Farthing, the Adjudication Registrar, to commence the formal section of this presentation.
At times throughout the course of the session, you'll hear me refer to the registrar or the Adjudication Registrar. This is intended to be a reference to the statutory role and specific functions that attach to it, rather than an impersonal reference to myself in third person. I also wanted to point out that at times throughout the proceeding today, you might hear a little bit of background noise. We are experiencing some renovations outside of the building, so if it is a bit noisy, please bear with us. In addition to that, and lastly, before I get started, in terms of the format for today, I'd like to acknowledge that this session is a little bit different to what you may have experienced in terms of your previous engagements with the registry. For many of you that I have met and worked with before, ordinarily, I'd like to be able to do that in a room where we could engage together and flesh out some of those key points in person. But today, as a sign of the COVID times, we are limited to a virtual room. Please don't let that detract from your experience with our session. As Regan mentioned, our team have worked really hard to make sure that we can take your questions and meaningfully engage with those at the end of the session. So I do encourage you to get involved and ask any questions that you might have. So I can see that the PowerPoint is up and ready to go, and we'll get started. On the 23rd of July 2020, the Building Industry Fairness, Security of Payment and Other Legislation Amendment Bill 2020 received assent. And now the Building Industry Fairness, Security of Payment and Other Legislation Amendment Act 2020, a big name referred to as the BIFOLA Act, amends various legislation, including the Building Industry Fairness Act, the BIF Act, and also the QBCC Act. A significant portion of the amendments commenced on 1 October, including the reforms affecting progress payments and the adjudication process. Remaining amendments, including a staggered approach to the trust account regime, for example, will begin earlier next year. Many of the changes under the BIFOLA Act have come about as a result of law reform reviews, industry feedback, and state government commitments to the building industry. The implementation and effectiveness of those reforms under the BIF Act has been the subject of review by the Building Industry Fairness Reforms Implementation and Evaluation Panel, and that panel released a report in March 2019, which made about 20 recommendations to improving the underlying objectives of the BIF Act. Additionally, the Queensland Government established the Special Joint Task Force to investigate subcontractor non-payment in the building and construction industry, with a number of recommendations in June 2019 in relation to the regulation of building industry participants. The BIFOLA amendments aim to address those recommendations of both the panel and the task force, including improving protections for subcontractors and increasing oversight of the QBCC. As well, managing the financial transition to the trust account framework and strengthening the financial requirements of the QBCC licensing framework. Turning firstly to the adjudication process, we'll have a brief look at some of the changes that are focused on obligations of claimants and respondents. Following an adjudication decision, a respondent that is required to pay an adjudicated amount to a claimant must do so within 5 business days of receiving the decision or within the time decided by an adjudicator. The BIF Act provides that it is an offence for the respondent to not pay that adjudicated amount within the required time, and penalties do apply. Enhancements through the recent amendments now provide regulatory oversight for the QBCC in respect of the respondent's payment obligations. The BIF Act now requires that a respondent must notify the registrar in an approved way of the payment of that adjudicated amount within 5 days. Email is an approved way, and the notice must include evidence that the payment has been made. That evidence might take the form of a bank deposit, for example, or a statutory declaration if required. A failure by the respondent to comply with that obligation remains an offence, and the obligation commenced on 1 October and applies to all decisions made after that date. The amendment of Section 97 of the BIF Act provides that where an adjudication application has been withdrawn, the claimant is now required to also notify the registrar in addition to the respondent and the appointed adjudicator. Notice to the registry by email is acceptable, and you may have started to notice that parties are tending to prefer one notice that informs all parties simultaneously of the withdrawal. This is a little bit different to how that notification has occurred previously. An adjudication application is considered withdrawn if the claimant chooses to withdraw it or if the respondent pays the full amount of the payment claim the subject of that application. The amendment of this provision will assist in collecting statistical data about the adjudication process and also the lodgement of applications. Failing to inform the registrar of the withdrawal may attract a penalty. However, I should note here, though, that there is no change to the entitlement of an adjudicator in respect of fees. An adjudicator remains entitled to be paid fees and expenses notwithstanding that withdrawal. I'll now touch on some of the changes that align to your functions as a registered adjudicator. Firstly, I refer to the amendment to the defined term complex payment claim. The BIF Act prescribed a definition of complex payment claim that was exclusive of GST. That definition has been amended to remove the reference to GST, with the effect that a complex claim now means a payment claim for an amount more than $750,000. Omission of GST from the complex claim is consistent with interpretation of the term payment claim set out in Section 68(1) of the BIF Act. The effect of the amendment essentially is that the assessment of the claim threshold may now be different. That is, looking holistically at the value of a claim, is it in total more than $750,000? It follows that the assessment of an application that results in a complex claim has obvious implications for the timeframe in which that application needs to be decided, and also in respect of the fee that will need to be charged for that application. Transitional provisions are relevant to this assessment. Section 4 of the Transitional Regulation provides that the amendment does not affect payment claims made for 1 October 2020, irrespective of whether such payment claims may have been adjudicated under Chapter 3 of the BIF Act. Turning to the time for deciding applications. Where a respondent does not provide a payment schedule in response to a claim in compliance with Section 76 of the BIF Act, then they are prevented from providing an adjudication response. Amendment of Section 85 of the BIF Act clarifies that the response date where no payment schedule was provided by the respondent is the last day on which the respondent could give an adjudication response if they were permitted to give one. Prior to amendment, calculation of the response date was unclear because the defined term did not, on its face, contemplate a circumstance where no payment schedule had been given. Arguably, in that circumstance, time was at large to determine such applications. The effect of the amendment is that the response date may be easily determined irrespective of whether a payment schedule has been given. And the amendment in turn clarifies the time in which an adjudication decision must be made. The time for making an adjudication response is in effect now included in the overall time for deciding the application, whether or not the respondent gave a payment schedule. Amendment of Section 86 imposes a new obligation on adjudicators to now notify the registrar of an extension of time to determine an application. That notification must be made within 4 business days after the extension is agreed with the parties, or in the case of a complex claim, within 4 business days after the adjudicator has decided, due to no agreement between the parties, that additional time applies to decide that application. Notice of an extension may be made by email to the registry, and the amendment will assist us in fulfilling our reporting functions pertaining to applications. Amendment of Section 88 of the BIF Act clarifies notification requirements in respect of adjudicators' fees. The Act provided that an adjudicator must provide a copy of the decision and notice of the fees and expenses to be paid to the registrar at the same time that that information was provided to a claimant and a respondent. Because fees are generally paid prior to the release of the decision, this was often a zero value and thereby not achieving the intent of the legislation as it was currently drafted. It was suggested to be unclear whether the obligation extended to notify those fees and charges that had already been paid prior to the release of the decision. It's clear now that an adjudicator must report to the registrar and the parties all fees and expenses that are both paid and to be paid at the time that your decision is released. The existing maximum penalty of 40 penalty units in respect of that provision remains unchanged. And finally, looking at adjudicators' fees, Section 95 of the BIF Act amends the requirement for an adjudicator to charge reasonable fees to ensure that they are not entitled to be paid more than is reasonable, having regard to the work done and expenses incurred in determining an application. An adjudicator is not entitled to be paid any amount that is more than the lower of either a reasonable amount, having regard to the work done and expenses incurred, or the prescribed maximum fee in respect of that application. So by way of example, where an application involves a progress payment amount less than $5,000, ordinarily a maximum prescribed fee of $620 would apply to that application. If it turned out on an assessment of the application by the adjudicator that there was very little documentation in respect of that application, and there were little to no submissions, and it could quickly and easily be ascertained that there was no jurisdiction to decide the application, then an adjudicator may consider that a reasonable amount to decide the application, having regard to the work done, is lower than the prescribed fee and only charge that lower amount. If that was so, the adjudicator would not be entitled to be paid any more than the lower of the 2 relevant amounts. And as I indicated, that is the reasonable amount for the work done in this case, rather than the maximum prescribed fee. It is important here to say, though, that what is considered to be a reasonable amount for fees in respect of an application remains a matter for determination by the appointed adjudicator, having regard to the circumstances of the particular application presented to them. I'll hand over to Megan Johns now to take us through new obligations in respect of the payment claim process and important enforcement measures for unpaid adjudicated amounts.
Thanks, Sheridan, and good morning to everybody joining us today on the webinar. When I was introduced earlier today, my name is Megan Johns, and I'm leading a team of QBCC staff who are implementing or supporting industry with the changes to BIFOLA. So in addition to the changes to the adjudication process that Sheridan has just covered, there are also a number of other changes to the BIF Act impacting on the payment claim processes, and there are also several new payment enforcement options introduced by BIFOLA. A general awareness of these changes may be important to your role as adjudicators. No doubt you would be familiar with the payment process and the payment claim requirements in the BIF Act, which are shown at a high level in some key steps on the screen right now. Through BIFOLA, a number of new requirements have been introduced which change or enhance these required steps. The first of these is the introduction of supporting statements. BIFOLA has introduced a new requirement for supporting statements to be given by subcontractors with their payment claims. Other states such as New South Wales and Victoria already require supporting statements. A supporting statement essentially confirms that subcontractors have been paid, and if they have not, provides reasons why. This requirement commenced on the 1st of October. Head contractors now need to ensure they provide a supporting statement with each payment claim given in relation to their construction contract. This new obligation applies only to the first-tier contractor who has contracted directly with the owner or principal, and this person we commonly refer to as the head contractor. The requirement does not apply where the contract is with a homeowner for domestic building work, and a head contractor only needs to give a supporting statement if they actually have subcontractors working for them. The requirement also does not apply to subcontractors and others down the contracting chain. It is an offence not to give a supporting statement when one is required. A penalty will apply for not giving that supporting statement, and a penalty can also apply if false or misleading information is provided in a supporting statement. Importantly, not giving a supporting statement does not make the payment claim invalid. So the person or principal receiving that payment claim, regardless whether the supporting statement is included or not, must still take action to respond and pay. Another change under BIFOLA is the introduction of a new offence for non-payment. You would no doubt be aware that it is already an offence not to pay the full claimed amount in the absence of a properly given payment schedule. It is now also an offence if a respondent gives a claimant a payment schedule proposing an amount that they intend to pay and then does not pay that scheduled amount by the due date. This change addresses an anomaly to ensure the offence applies to all situations of non-payment. So turning now to provisions relating to enforcement and legal proceedings, one reform worth quickly mentioning concerns the warning notice required to be given by a claimant before they commence legal proceedings. The warning notice needs to be given to the respondent now within 30 business days of the due date for the progress payment. You would no doubt be aware of this date or time frame previously required the notice to be given within 20 business days. So there is a slight increase in the time frame for giving that warning notice. This change applies for notices given in relation to progress payments with a due date of 1 October 2020 or later. So transitional provisions apply in relation to that change. So in some cases, a respondent does not pay an adjudicated amount. So aside from the fact that this is already an offence not to pay an adjudicated amount and that attracts a penalty, from 1 October there are some new options to help the claimant secure payment after adjudication. BIFOLA introduces a new payment withholding request. This is an option for claimants who have not been paid after an adjudication process that may help them get paid. The payment withholding request works by requiring the person or company directly above the respondent in the payment or contracting chain to withhold payment from the respondent. Unlike subcontractors' charges, it cannot skip or leapfrog persons in the chain. The higher party can only be the next person in the payment or contractual chain above the respondent. Generally, this will either be the principal or developer or a head contractor in relation to a payment or an adjudication decision owing money to a subcontractor. If, however, the claimant is a head contractor owed money by the principal or developer, the payment withholding request can also be given to a financier for the project. A hire party, however, cannot be a resident owner, and the request cannot be used against a resident owner. If the hire party no longer owes money under the contract to the respondent, the payment withholding request can also not be used. The hire party so after receiving a payment withholding request, the hire party withholds progress payments that are or become due after they are given the form. And they only need to hold the amount up to the same value as the unpaid adjudication amount. There are serious consequences for hire parties who fail to comply with payment withholding requests. The hire party might be liable for the amount and subject to a penalty if they ignore the payment withholding request. However, the hire party is also protected from any recovery action by the respondent for that withheld amount. The second new option is the ability to lodge a statutory charge over the property. But this option is only available to head contractors who have a dispute with a principal or developer. A charge over property registers an interest in the property for the adjudicated amount. The claimant needs to have an adjudication decision first, and this also needs to be filed as a judgment debt with the courts before the charge can be lodged. The head contractor then can, using forms available from the Land Titles Registry Office, lodge a request for the charge to be registered over the property. This form needs to be submitted with a copy of the adjudication certificate and a statutory declaration stating the amount has not been paid. A charge has the effect of preventing the registered owner from selling or dealing with the property until the charge is lifted. And fees apply in relation to making those requests for a charge over property, which is done through the Titles Registry Office. The QBCC is not involved in the process of registering the charge. This option can only be used by head contractors, as I said before, owed money by the principal or developer. And it can only apply if the relevant property where the work was carried out is actually owned by the respondent or a related entity of the respondent. And again, properties owned by resident homeowners are also excluded. More information such as the required forms and guidance material on the operation of the charge over property is available from the Land Titles Registry. So that brings me to the end of the short overview of the key changes included in BIFOLA. I have only briefly covered these today as an initial introduction, but more information is available on the QBCC and DHPW websites.
Thanks, Regan. So to round out a very brief recap on what we've looked at, we've provided today an overview of the key changes to the adjudication process through the BIFOLA reforms, and we discussed the changes that impact your work as a registered adjudicator, including consideration of defined terms, for example, complex claims, and the relevance of those amendments to the assessment of adjudication applications. We then looked at some enhancements to the adjudication process, including clarity in respect of timeframes for deciding applications. And we touched on the increased payment protections and penalties to strengthen the security of payment agenda, and Megan took you through those. We also heard from Megan about the new measures designed to support enforcement of adjudicated amounts. As we've mentioned, the reforms commenced on 1 October 2020, and from that point must be considered when deciding adjudication applications. Finally, I'd like to draw your attention to a number of key resources that might assist you in respect of your work. More information about the reform agenda is available now on the QBCC website, and that information has been updated to include new provisions and information around the adjudication process. We have developed, as we've heard at the start of the session, a resource pack that we're going to provide to you after the session, and that in that pack includes a guide for registered adjudicators that outlines the changes to the BIF Act, very similar in look and feel to the transitionary training document that we provided earlier on in the year. And this information, as I said, will be included in the pack along with a number of other relevant resource material. What I would say, just as a final point, is that we have skipped through very quickly today and covered at a very high level a number of the changes. The Adjudication Registry is available to assist you after the session today with any questions that you might have, and you can contact us in the ordinary course as you do by email or telephone if there's anything we can assist with. Back over to Regan.
Thank you, and thanks for coming along to today's webinar. Thank you very much, Sheridan and Megan. Just for transparency for yourselves, when you go back and watch this, I'm thinking if everybody's comfortable, Sheridan, I think this mainly impacted yourself and myself at the very beginning. We might just re-record the first couple of slides. So just give us a few days to do that, get that together and edit, and then we will send out the PowerPoints, a link to the presentation, and so you can actually see the slides that were missed in the beginning and actually watch the whole thing again in that consistent format. Thank you so much for your patience as we went through that technical issue. I'm sorry, my screen froze. And don't forget to claim your CPD point for your attendance by recording this webinar as a CPD activity through the online My CPD portal. And as I said, we really appreciate your feedback on this presentation, technical difficulties notwithstanding, and your webinar experience today. So please provide your comments in the survey that will appear at the end. Thank you very much for coming. Have a wonderful day.